Hi everyone. Thanks Shaleen, as yeah, Shaleen has made me into somebody who talks about technology for a long time, even though we have many other conversations that are fascinating. So I'm actually quite excited to be with a very unique set of practitioners on the stage. Sid, Moss, who has been a friend for a very long time, and Noor. We missed Nanditi, but hopefully in the future there'll be an opportunity. So, the conversation today is going to be rather fundamental in the sense that we have been thinking about what is our approach to technology and how do we kind of approach technology from today's standpoint. It also stems from my recent learning of teaching the course on technology in art in Ashoka University, which is about thinking about technology in historical context. So the first question that we would like to pose today to ourselves and to the panel, and hopefully we'll have a conversation after the discussion, is what is technology? And for me, one of the most important things about technology is the fact that it needs to be historically related, because when we say tech today, it's mostly within the space of the digital media technology that has emerged in the past 10, 15 years. Yeah. But at the same time, when you actually teach something like that, you go back to almost photography, then to video, then to internet, and so on. So the fundamental point I'm trying to make is to say that technology as such, it needs to be historically located, and what I would say not taken for granted as an idea, just to kind of ease out those common assumptions of saying what do we mean by technology. And Sid, do you want to take over from there?
Yeah, sure. If you look at technology, you can go back to the Egyptian civilization, the Indus Valley civilization. There were seals that were made, there were techniques for channeling and sort of rainwater harvesting. There were methods to mummify pharaohs and other folks. All of those, if you contextualize those in today's times, these would all be eligible for getting copyrights, patents, trademarks, designs. So what's really occurred is art has allowed technology to evolve. Technology has enabled art, but its origins start from perhaps the time that we can first see cave paintings that we've seen. I think that evolution, what it has done is, it has allowed us, there's a landscape where the change has been recognizing authorship and the use of that as far as the law is concerned.
Well, I just start from technology, the word technology. The etymology of the word comes from this Greek root techne, which is techne and logia, logia is system. Techne actually is art, craft, or skill to reveal a quality in something, or to discover something from something which already exists, like a rolling pin from a piece of wood, or a tree house on a tree. So it is, there is something. This is where the word technology comes from. So it felt pertinent to kind of frame this panel to begin with from this place, so that we can really, we're really talking about technology as pen being technology, paper being tools of tools actually, to then produce knowledge systems, ideas, art, and so on. So when we talk about technology, sometimes it can be that we imagine digital technology, or even screen-based things. So maybe this is a good starting point to kind of say what we are talking about when we say technology to begin with.
Yeah. I agree, and I endorse what you both say. I think what's very interesting is the fact that you say tools, because we have to question technology as it was, for instance, the cave paintings. They were used to communicate, so they were a tool to communicate. And technology is used for a purpose, but that does not mean it doesn't have a value in and of itself that can be protected increasingly we're seeing that technology has a value, both artistically and from a legal perspective, to be protected, because it's not just the means to the end, it's the means as well.
As an add-on to that, since we have on technology, I think one of the, since we are in India, parents only have to speak about art. So the relationship between tech and art, which is something that for me is two facets. One is art that is made with technology, which we call digital art or new media art or things like that, and also the art that is mediated or circulated through technology, which is, I always say that the most number of exhibitions today are actually seen on Instagram. The most number of artists today are researched on Instagram. So in a way that we are in a space where even the physical art needs a kind of a digital afterlife to be able to have that circulation potential. And as if like you're not an artist if you're not on Instagram. Unfortunately, that's the reality, but at the same time, these two important distinctions are necessary, especially in the space of talking about it, according to me. And Sid, would you like to enter that from the law perspective?
Yeah, I think we're a country which has perhaps the only illustrated constitution in the world. You don't have constitutions which have illustrations otherwise, and so the helium-filled tank where our constitution sits, the original version of it, actually has illustrations on pages prior to each chapter, which sort of draw their strength and their origins from historical milestones that we as a subcontinent have gone through. And so, whilst they are not part of the constitution, it has been a decision to integrate these illustrations in the very fundamental law, which is meant to be both a governor of ethics going forward. It's supposed to be the originator of laws which will govern our relationships inter se in society. It's also the one from which intellectual property laws have thereafter emerged. So we're quite a different vantage point in India seeing this. And I think, just to contextualize one more thing, most people think of intellectual property in law as being a more recent phenomenon in India. Just to let you know, the first patent law that we had in India was in 1856. And so people talk about copyright, trademarks, and this as if assuming it's a new thing. It isn't. It's been there for a while, but its awareness and the need is now sort of more important than otherwise.
Well, I find it fascinating to say you said that we have illustrations in the Constitution, but they are not part of the Constitution. I mean, I would just from that sentence, I would say that they are part of the Constitution because they produce the psychological effect, and I suppose in that way that is what is interesting. That the decision to have that, to have imagery, which doesn't necessarily which cannot be pinned down in the same way as when words can mostly, but also not. We are always trying to find the wriggle around words. So it is that we do have illustrations that are within the Constitution, and they are perhaps producing this psychic space for someone who reads the Constitution.
Oh, absolutely. I think lawyers have been trying for a while to sort of weave that way in, so that courts can see it that way as well. Limited success, but so they keep the text apart from the illustration, but very much a part of what it is.
It's conceptually interesting.
Yeah, I agree. I think the case of lots of cases in the US which have to determine whether something is appropriated or not, and they have to visually. It entails a lot of subjectivity, images. And one would think that words would be objective. Actually, increasingly, words themselves, we have lots of different iterations, and as things develop, even words can be sometimes more confusing than visual. And there's a children's book that I remember reading called The Phantom Tollbooth, and I don't know if anybody has read it, but it's amazing. The kingdoms of Digitopolis and Dictionopolis are fighting. Digitopolis says words are more important than numbers are more important than words, and Dictionopolis says words are more important. What about visual And I think that goes to what you're saying. And to have an illustrated constitution, if we all know what we mean by those images, they actually can evolve and create in a more universal way than words which are laden.
Also, just to kind of extend the conversation is that idea of tech and art is to see, we've discussed this, which is to think about what is the relationship between social reality or reality as we speak and the fabric of technology. By that I mean that from something that being an extension of the human subjectivity becomes to becoming something that conditions the human subjectivity. As we speak, we are in the post-AI world, it's safe to call that. And to think about what happens to human subjectivity, also what happens to social realities in the way of it. And also I want you to lead from this, and because it will be nice to hear.
Ursula Le Guin, who's a science fiction writer. Well, a lot of science fiction writers did not consider her a science fiction writer. So it was said that she's not even, she doesn't have hard technology in her writing books. But the way the sentence which was like how does society cope with physical reality? Actually, through time, as we spoke about right now, we have a historical perspective to deal with here. How does society cope with physical reality? We are all have always lived with what is known, what is the human condition, or the condition of actually wondering why we exist, so to speak, and this is where, this is the space of thinking about. We are right now in the middle. We are mediated through mics, we are mediated through signals. In this room, we are in the soup of, so to speak, the soup of the technological soup. Chairs are a form of technology, of course, because they do something. They're there. They have a purpose. They have a function. But more than that, it's how we mediate with the physical world. And as we are entering into this, now we're entering into a network world. It's been 20 years of 40 years of the internet, and then 20 years of Google, and then I don't know how many months of ChatGPT. This is but what is happening is that it's like the particles of media are also running through our blood in a way. And how we are coping with our physical realities technologically mediated. So to say, we all seem to be, there seems to be a rush to catch up with something which is outside of us, which is technologically driven, which we must all, we are being dragged, we are being pulled and dragged by this fast pace of technology. And here, when I say technology, it is this idea, it is this sort of idea of what it is. Whereas, so in my practice, I like to kind of, for myself, come back to some questions of, what we're in very early stages of technology. I've used the word too many times now. I just don't want to say that anymore. But we're in very early stages, which means that what we think or what we imagine it to be now is going to have profound effects into the future. And how I, for myself, for example, frame what it is, because then I mediate my world through it in a way that I choose and I tailor it in a way. And I think this is something that I find a way to kind of ground oneself before this sort of trying to catch up with the fast pace of technology. I have much to say about my about how and what and why as we go into
What's your view on cancel culture? What if you don't want to be part of this being dragged into something? What do traditional artists who don't say want to be part of this get not dragged into it? But everybody has that. Everybody has social media. You don't want to show your work. How do you negotiate that?
I personally do feel that this is a question one asks every day. So as an artist, you ask this question every day. how do you negotiate this reality? The reality that I want to produce, the reality that I want to live in, and the reality that is sort of pre-existing under a neoliberal capitalist push. But that is not to say that is not to say that I am. Which is why we started with what is technique, what is technique. I use I write code. I use computers, speakers, many all forms of mostly all forms of media and technology, zeros and ones production for producing actually affect, to produce knowledge, to produce to actually communicate with say insects and dolphins as we were speaking about. And this is so the thing is not, I mean, to answer Noor on what if you don't want to be dragged, but actually that is a big question. So you don't want, you have to tailor it for oneself. It's like I feel that since we're at such early stages, I feel that it is consumer tech actually that is all that we are actually seeing, because we're catching up and we're seeing consumer tech. But for me, it is that what do we have in how do we tailor the world around us? Like we always mostly this. So how do we tailor the world around us? Like you get a shirt made, it's the same thing. I want something to be known about the world. I want to produce a reality around me. How do I do it through different technologies?
Also, just to respond to that, is that there's a beautiful book by Jenny Odell called How to Do Nothing, and I highly recommend everyone in the room to read it, because I think it has fundamentally shifted my approach to. And Jenny Odell actually says that you don't have an option of living outside of technology, actually, unfortunately, unless you want to live in the middle of some like sea where still there will be signals and Wi-Fi. But what she's talking about is the fundamental reorientation with your relationship with reality. And I think it's quite beautiful where she maps different kinds of similar collectivities, more where have wanted to move away from the existing status quo and wanted to create parallel communities, ecological communities and so on, but have had their own challenges and hurdles in terms of how do they be there in that community and coexist within the larger reality that's called the world. And I think it's a beautiful book just to kind of see, okay, if this is overwhelming me, how do I reorient myself to my own relationship with the skin and life that is around me. And there's a beautiful chapter in On Bird Watching I highly recommend.
But I can tell you one thing, as far as the law is concerned, the law is definitely being dragged forward in the future, and I'm very thankful to that actually. Partly because we moved from real property to intellectual property. We moved to a time where if someone created a piece of work, it was considered like cattle. At some point it was treated like women as well. It was considered as chattel, and it was transactional. And there wasn't a recognition of creatorship, authorship, as far as this was concerned. And we've moved to a system which, besides the actual artwork, now recognizes that the person who creates it actually has rights in it. And we've moved further than that now as well, where we move to a point where the work itself perhaps now has a voice itself. We're sort of breaking into that area right now. I'll give you an example. Leonardo da Vinci in 1495 created the first essentially diagrams for a working humanoid. And at that point in time, it was a knight in armor whose jaw would move up and down, and he could stand up and move his hand, and he could sort of do very minimal sort of human actions. And now in 2017, we have a humanoid which sort of using art and technology has fused to being this persona who Saudi Arabia has granted citizenship to. So we've moved to a point where there were drawings which, was someone could buy and sell those drawings, it didn't mean anything, to a point where you now own rights in your work, including moral rights, even if you give it to someone. And we move further than that, where the artwork itself, the ultimate product, is considered to be perhaps equal to us. Perhaps their capabilities are not enough to vote and do things we are, but someone's already taken the step to put them on a pedestal which is equal to us. So it's challenging, and it's something we have to navigate.
May I add to that is that I agree that the law does govern the technology and the basically deal in that. One has to really be aware we are still, unfortunately, depending on where you are, sitting within a system of nation states. Each nation state has its own laws, and not every single law is uniform. So, for instance, Copyright and Patents Act in the UK, 1988, it's really all needs updating, especially, for instance, in relation to AI, who owns AI, copyright, exceptions to copyright, for which photographs are treated in a different way to others. Copyright itself in Anglo-Saxon countries more verged towards a commercial kind of exploiter of, produce of the film. In France and in civil law, it's really vested. There's more artists, like the artists retain control. So you have to be aware of where you are also and not to be complacent as that there is only one big law that basically governs copyright and patents and trademark and whether they do come up to speed with the new technology.
An interesting fact I think I want to know is, the whole system of intellectual property didn't sort of earlier in its days, before it was individually recognized, it was more a royal prerogative, where Her Majesty or someone essentially appointed someone to be a supplier for, and that was supposed to be the endorsement for quality and recognition which others couldn't breach or violate. And then it actually took a law to ban that, to create the intellectual property system that we know today. But we've also had instances, for example, at some point, a little known fact is, the Netherlands at one point in time decided that it didn't want an intellectual property system at all. And they decided to throw it out of the country entirely. Of course, that lasted for a short while, but then they had to bring it back. But it's very interesting where countries have taken this decision for themselves in this fragmented system like Noor talked about, where you can decide for yourself whether you want to or not. I think we may be a bit far down as far as the process is concerned in India, but these are examples where people have sort of, it links to your question of, or Noor's question of, what if you don't want to be dragged? It takes an act of active will, whether it is political or individual, to make that conscious decision. And there's an example of where a country state has done it.
And digital art, when it crosses borders, what do you do then? Which law applies?
Well, I think that brings me as a nice segue into this conversation about how do you regulate the violation in the framework of the state. And I think it's interesting because it's a question to ask whether I can choose to be not a citizen and whether being not a citizen is any existence at all, I think it's very interesting because the fundamental to human subjectivity, as she said, pointed out, is the nation state, because you're identified at the moment you walk out of your home. From banking to every kind of institution that you're implicated with, citizenship or citizen is the fundamental kind of being, and of course the nation state becomes automatically implicated in it. But going a little ahead from that, to think about how this, and this is something we have also discussed, is that how this, in the framework of tech, art and law, how does breach is framed by the state, because the state always responds to violations on a case-by-case basis and wants to regulate these violations, stating that, okay, you've done enough kind of mess up, I'm going to tell you to stop now. But at the end of the day, that the state has that authority to kind of shut down anything, and that's why I keep telling people who think global is endless, tomorrow there might be a time where they'll be like, okay, you're done, you have to pull the plug, and just imagine what will happen to the world. And it's totally possible, and it's just a matter of a small, and I don't want Google to shut down, don't get me wrong, but it is totally possible just with one plug, whole ecosystem that it has created can just collapse, and we will be bewildered and running back to our Yahoo accounts that we created 15 years ago, which we didn't use. But I think it's important to think about what is this gray area that we seem to, and Wendy Chun, a scholar I really appreciate, she calls it the bleeding edge of obsolescence, that we think for some reason something that is so obsolete is so permanent. And I think it's a beautiful way of formulating the constant conundrum, and I kind of brought it from a solid seed, that it's like a fluid and solid at the same time. I want to kind of go back to the gray area question, which we were discussing, where the violations and the regulations are somewhere in sync with each other. And I think that they want to take a lead on it, because it is pretty much within the framework of legality.
So can I deepen that a little bit first? So I'll give an example. We have, for example, someone client who's decided that they're going to print because 3D printing technology has become so accessible, and so has stem cell research. It's sort of more widespread than it has historically been. These folks want to print organs, but they don't want to just print organs for sort of grafting for medical needs. They want to print organs and then figure out combinations to aggregate different organs and see if they can pump life into combinations which are not ordinarily known. Now, they're on the verge of trying to figure out, where do I fit? Another example, we've got a client who's figured out software which they put devices under the ocean which records, detects and analyzes dolphin communication, and has moved so far along that they claim they're close to 80% there to identify how communication between dolphins take place. But the bigger issue is that the software they've developed, you can feed anything into it. Series of sounds, you can feed it hieroglyphics, and it claims that this is the method to decode them. And that is under our current regime protectable. It can be in the exclusive domain of someone who creates it. The methodology to actually achieve these results. So we have these real issues which we are already facing today, where we have this issue of what is the law, but also what are the ethics that need to breathe life into these laws, and therefore where are we on them at this point in time? I think we were having a discussion about how do you put ethics into place in addition to regulation, so that there's some element of driven direction for people. And the Constitution, for example, has done this at some point in time, where there's an innate respect for the human being. The directive principles of state policy, it's more individuals have rights at this point. Other living beings should be protected and shouldn't be harmed, but they aren't equated at this point in time to what human life is, but we're getting there.
Yeah, to talk about this humanoid, the agency actually, this aspect of agency. I mean, we're talking a lot about the agency of, say, artificial intelligence, and that brings to copyright, of course, produced by and so on. When we're talking about artificial intelligence, I just want to break that word, like deconstruct that word a little bit. Actually, the word artificial intelligence came into existence as a tool for scientists, for researchers to get funding, because this specific word, artificial intelligence, and this has had a great impact. But now that I'm interested in talking about artificial intelligence and agency in this way, because then what is, it asks the question, what is intelligence? Again, to bring this question of breathing life into a set of organs that are 3D printed. So what it means to breathe life into it, or like for it to exist, is that it produces some kind of conscious agency. And conscious is also, I would use that word, so scratch that. Like agency, which is then, when one can ask this question, what is the agency of anything intelligent? And if we are talking about artificial intelligence, then what about the intelligence of millions of species which is presently? Because that really, then it broadens the question. It broadens the question to society, to the law, that if this humanoid has citizenship, and a tree only began to be considered alive about 100 years ago, when JC posted an experiment where he proved that trees are life, plants are life. So this is, I find it also very interesting that the moment we're talking about this kind of a thing which is outside the human, we are also inevitably also looking at a thing which has always been outside the human, which is the non-human, which is what I'm always striving to be. I don't identify as human. I don't also identify as post-human. That's or augmented human, or I'm just trying to run away from
Just not.
humanity.
I think it's a good space to be.
I was going to say I wanted to come to bring this back within the legal aspect, like as a lawyer, I was trying to drive back to legal. You mentioned something about what happens to Google, what happens to everything. You trust the cloud, you trust Google, you trust this. I did have a discussion with Mark Phillips, who is the general counsel of Phillips Auction House. I think one thing that has not yet arisen in relation to, for instance, creation of digital art on blockchain is that what happens if the relationship is dependent on the server working? What happens if the server is not working? So the law is concerned with natural persons and, companies and things. These gray areas are not covered. Who do I sue? Who do I go against? Who is the defendant? Who is the claimant? If they don't exist anymore, who has the obligation? If a machine is creating an AI image, who is the author of those images? And so, and also, we go back to rights. The rights of, we're going back a long time, but say mummies, they're still, we're exhibiting mummies in museums, and they just value them. Again, they were human beings, and they have, there's a link to another thing. There are whole books in the US covering, say, human remains, but also this whole cultural aspect of it all. How do you, from a legal perspective, regulate? How do you define what is falling within the arts, what is falling within the property, and who are the players?
I think this is the perfect point to ask some questions here towards the end almost. Open to the audience to ask any questions because we've been talking since the morning. So it's just once again what others have to say. I know I see a very familiar faces who I'm sure will have few things to say.
Could I just put one thing before we check? One thing I just want to leave people with, it's just a story, it's not an analogy, and it kind of goes to technology. Is I went to, and just one thing I want to leave artists with, and creators, and producers, film or whatever. I was recently in Jaipur and I went to a textile factory. And, this is an example of textile made with 3 blocks. This is an example of one I made with 3 blocks. What's the difference? With this, the blocks relate with every element is the ownership of the factory. They created the blocks, they have to paint. This I created, but I only have ownership of this. I cannot make anything else from this without authority. They can. Now, there's no difference between that and digital. We have to get out of the concept of, something is tangible and something is not. I think the thing that one has to go away with it, a discussion I had with an artist, Michael Fines, who created a project, amazing project called Yugen. If you see it, have a look at it. It's analog, but fantastic, better than the best TV. Is that she said, I made sure in the film industry, everyone is paranoid about owning every single little thing. If you have like a picture of a picture, and inside that picture there's like a Andy Warhol, whatever, you need to get the licenses for that. So make sure that even the software, the hardware, whatever you're creating digitally, don't be lazy. Find out who owns it. Get a license and own it. Because that's going to protect you in the long run. That's just the thing that we believe in terms of the legal.
Just in terms of a practical takeaway for artists, I think be conscious that you have multiple lines of intellectual property which you can use. If you have something which is a painting, if it is something which is sound related, it's copyright. And copyright doesn't need to be registered. You own it from the time you create it. However, once you register it, you have it for your lifetime plus 60 years thereafter. In the UK, it's 70. It's an example of how it varies based on jurisdiction. On the other hand, if you were a sculptor and you wanted to create a frame and you want to create a piece and it was a design, you don't get that much time. It's significantly lower, 10 to 15 years. On the other hand, if you have a patent, if you have a trademark, You can get a trademark and you can continue it for blocks of 10 years in perpetuity. And on the other hand, if it's a patent, 20 years, and then it's in the public domain. This is an example of how different forms of expression, whether it's technological or art-based, are treated differently currently in our system. And there isn't a rationale for some of these numbers. Why shouldn't it be 65 instead of 16 or 17 in terms of 15? There isn't actually a logical reason. And that will perhaps change over time.
And one thing is, if I want to do a shameless promotion, anyone who wants to know UK English law and the art and business and in a readable format, this is a great book by Martin Wilson of the Phillips Auction House. So it basically goes through a lot of things within digital.
Can't hear you. Can't hear you.
Oh.
This is a great book by Martin Wilson, who's General Counsel of Phillips, written in a very, very clear style on UK law, on English law, as it applies to so many things, digital, copyright, auctioning, selling. So if anybody felt like having a handbook on this in English law, to give a introduction, I agree with it as well.
I just thought it was important because the earlier question, the earlier idea of looking back on the future of technology, by giving us new, the razor sharp edge of obsolescence and so on. I feel that to view whether tools and new technologies or older ones as not as a field, as a landscape. So actually, in a landscape, you choose parts of it. I mean, you said, there's a lot, and it's possible to really tailor for oneself and not feel that one's being pulled through or pulled with technology. Because just to say that it's a much wider landscape.